Alvin Bragg blown out of a federal court in the Southern District of New York, the judge rejecting his request for an injunction. And there was a back and forth that took place in the courts, and they were fighting back and forth. And we already read through Jim Jordan's response. The name of that video is Jim Jordan Obliterates Alvin Bragg, because it was excellent. And then it went into the Southern District of New York. The judge has considered everything and now issued the ruling. Here's what it says. The opinion and order coming out of the Southern District of New York in the case of Alvin Bragg, Manhattan DA. In the case against Jim Jordan and Mark Pomerantz, the former Manhattan DA, who has been subpoenaed by Congress, Jim Jordan, as the chairman on the Committee of the Judiciary, sent the subpoena this way to Mark Pomerantz. And so Bragg is now hitting both of them, saying you're both silenced. That's the request. The judge doesn't agree. Filed on April 19, 2023, this is the opinion and order denying the temporary restraining order. Sorry, Alvin. This is Congress. Who do you think you are, buddy? The judge writes, Mary K. Visikill. The request by Manhattan DA Alvin Bragg for a temporary restraining order, enjoining enforcement of the subpoena, stopping the subpoena, is denied. The subpoena, writes the judge, that came out of Jim Jordan's Congress was issued with valid legislative purpose in connection with congressional power to conduct investigations. The judge is doing the same thing that we saw a lot in the J6 stuff. It is not the role of the federal judiciary to dictate what legislation Congress may consider or how it should conduct deliberations in that connection. Mr. Pomerantz must appear for congressional deposition. Look at this. Look at this one. Look at this. No one is above the law. Oh, gosh, it's going to be a lot of fun to say that in the next, decade or so. No one is above the law. Indeed. Yeah, and this is what the January 6th psychopaths were saying for a long time. Nobody's above the law. Nobody's saying he's above the law. We're saying there was no crime committed. Weirdos. Stop making something out of nothing. You're criminalizing conduct that your side has been doing for years. It's part of the standard playbook. So we're all about equal standards. You're right. Nobody is above the law. It's going to be a lot of fun when more subpoenas go out to everybody else. If the Republicans decide to grow a pair, and maybe they are. Maybe this is the first budding of some activity. Courtesy of Jim Jordan. Says on April 6, the Committee of the Judiciary of the United States, the House of Representatives, issued a subpoena to Mark Pomerantz, a former, look at this, pro bono employee. He was working for free. That's how much he hated Trump. I don't need any money. I am paid in rage. Just allow me to take my aggression out on him. I should be paying you, is something that I think he hinted at. He says that he was the Office of the District Attorney General attorney pro bono. He got a valid subpoena to appear. The subpoena does not request that Pomerantz produce any documents. We want your butt in the seat. The subpoena was accompanied by a letter from the committee, Jim Jordan. The letter requested Pomerantz appear due to his, quote, unique role as a special assistant in the district attorney's office leading the investigation into Trump. Jordan also explained that Pomerantz already discussed many of the topics relevant to this inquiry, and he published a whole book about it. Jordan notes that the district attorney's office of New York has also, in the letter, acknowledged it used federal forfeiture funds in its investigation of President Trump. There you go. It just basically automatic, right? Oh, federal funds. Okay, so therefore it's Congress's jurisdiction now. That's it. Easy. That's why they throw their money at everything. So they get authority to regulate all the things. And the committee that was considering potential legislative reforms like broadening the existing statutory right of removal of certain criminal cases from state court to federal court. So there's a concept that exists. We have parallel systems of law, right? You have state courts, and you hear all the time about federal courts. And you see here we cover both cases in both courts. And in the state courts, we often get footage of what's going on in there. See Derek Chauvin, see Kyle Rittenhouse, other cases we've covered live. But other cases in the federal courts, they operate under a whole different set of rules. And they just say, well, no footage at all. We see Ghislaine Maxwell. We see the Proud Boys, which we're covering now. So we have different rules. And one concept is the feds, in some cases, can just go in and take a state case and just gobble it up into federal court. It's called removing from state into federal court. And there's certain reasons and justifications for that happening. Sort of like in the movies, the feds come in, this is my investigation now. And you go, oh, no, it's not. And jurisdiction, and the guy punches the other guy, and it's a big mayhem. Same thing here. But Congress is saying, well, hey, maybe there's an opportunity now, if you're going to be interfering with political candidates running for office, that Congress decides we're going to remove those cases and pick them up into federal court. And as we know, Congress sets the jurisdiction of the federal courts. So there's all sorts of authority here, layers of authority. The book that Pomerantz wrote references Jim Jordan's letter. It's called People versus Donald Trump, an inside account by Pomerantz. Gosh. Its subtitle indicates the book recounts Pomerantz's insider insights, his mental impressions, and his front row seat to the investigation, and his deliberative process leading up to the prosecution of Trump. Here are some of the things that he talked about. This is the judge clarifying for us. The judge is writing, here's what I'm seeing. I'm ruling. Mark Pomerantz said the following things in his book. When he was in the district attorney's office, the case against Trump arising out of a payment was referred to as the zombie case. That's interesting. I'm sure Jim Jordan has questions about that. Why was this called the zombie case? Is it because it was crap and you guys kept it around, hanging around his neck for political purposes? Yeah. The facts surrounding the payments did not amount to much in legal terms. Paying hush money is not a crime. This is a quote from the book. Even if the payment was made to help an electoral candidate. So it says, hey, it's not a crime. Making hush money payment is not a crime. So why are you prosecuting Donald Trump? Valid question for Jordan. Creating false business records is only a misdemeanor under New York law. That's weird. Hey, Mark Pomerantz, the DA's office is saying it's a misdemeanor. You know, those statute of limitations, those expire in 2 years. We are now 6 years plus out from the allegations. And so how can you possibly prosecute this if you say that they're only misdemeanors? Why are they suddenly felonies now? You also said, and he's referencing his book. Look at all these. So he's actually referencing, and I think he's footnoting the book. Let's see where this footnote is coming from. Yeah. So he's got all the exhibits down there. Okay, so we'll deal with that when we get to the end. This, he says, there appeared to be no felony state crime in play. No felony. That's a statute of limitations issue. He also wrote, to charge Trump with something other than a misdemeanor, Bragg would have had to argue that the intent to commit or conceal a crime had converted into a felony. But he says no appellate court in New York had ever upheld or rejected this interpretation of the law. So that's weird. Why is Bragg prosecuting this if that is the law? According to a prosecutor who worked in the same office that ultimately led to prosecution of Trump. This judge is quoting Pomerantz. He says that the charge is ambiguous. Says there was a big risk that felony charges would be dismissed before a jury could even consider them. Yeah, we're talking about that now. One of the biggest justifications for the dismissal is very likely going to be the statute of limitations, which we talked about up here. Says the Trump investigation should have been handled by the DOJ, not Bragg, obvious. Federal prosecutors would not have to torture or massage statutory language like we would have to do, right? They are twisting this thing into making it into something. Here, this emphasis was added by the judge. This was in Pomerantz's book. The same guy who's crying about Trump not being prosecuted. Says federal prosecutors previously looked into the Clifford hush money payment and did not move forward with the prosecution. All stuff that we have categorized. There is a statute of limitations issue. We know that. Numerous prosecutors were skeptical about the prosecution and were referred to as conscientious objectors, right? Divisions within the agency. The invoices and the requests for payments were made throughout 2017 after Trump's inauguration as president. And the team also discussed Michael Cohen's credibility as saying, yeah, it's one of the difficulties of the case. At one point, the judge says, Bragg commented the following. Bragg commented that he could not see a world in which Manhattan would indict Trump and call Cohen as a witness. Wow, that's a pretty big statement. You got to imagine Congress has a lot of questions about that one. What changed, Alvin? Your former prosecutor who was working for free dedicated to this has said you previously said nothing would come of this. But then Trump declared, and now here we are. What's going on? The judge says, While Pomerantz acknowledged Bragg's right to make prosecutorial decisions, he viewed himself as more experienced and more qualified than Bragg. Oh, wow. That's kind of racist. Why? More experienced and qualified? Does Alvin Bragg know that? Does Letitia James know that? That's racist behavior. Pomerantz then makes a point that he was finishing law school when Alvin was a toddler. Oh, wow. And that's also, I don't know, what is that? Like ageist or something? Gosh, I guess. So Pomerantz resigned, and he wrote that in his book. I don't endorse it. Pomerantz resigned from his pro bono position at New York when it became clear that Trump would not get indicted. Pomerantz told the DA that he was responsible for a grave failure of justice because he would not authorize Trump's indictment. Ultimately, in 2023, Bragg did, of course, indict President Trump, bringing back the zombie case and the theory back from the dead. So Jordan, the judge continues, Jordan and the committee first tried to acquire information from Pomerantz voluntarily. They sent letters, and we've seen the same game played. Send a letter. Hey, we just have some voluntary questions. Why don't we just come over and meet and confer and all the things? But on April 11th, Bragg, one of 5 district attorneys, filed a 50-page complaint in this court. And they named Jordan specifically and the committee and Pomerantz. Bragg filed a motion seeking a temporary restraining order and a preliminary injunction, stopping Jim Jordan from enforcing the subpoena and enjoining Pomerantz from complying with the subpoena. Okay, so Jordan, you can't ask for it, and Pomerantz, you can't give it to him. The government responded. The Congress responded back to Bragg. Now, the judge writes this, says, the first 35 pages of Alvin Bragg's complaint have little to do with the subpoena at issue, and they are nothing short of a public relations tirade against the former president and current presidential candidate, Donald Trump. Love that. It was. We read through it. The same is true of the vast majority of the exhibits accompanying the Boutrouf's declaration. The complaint acknowledges that Manhattan used federal forfeiture funds in investigating Trump. You acknowledge that you used the funds. And you also concede, Alvy, that the district attorney's office was aware that Pomerantz was writing a book about it. And you even asked to review a manuscript before it was published. Pomerantz said no. The judge says, at the heart of this, Bragg, your complaint, it simply includes 2 requests for declaratory and injunctive relief directed at a congressional inquiry. The judge says, look, the reality is that, as framed, this action is merely a motion to quash a subpoena dressed up in a lawsuit. Oh, man. Calling him out. The motion for a temporary restraining order was filed without notice to defendants, and before defendants were even served with this complaint. The rules say that any party seeking an ex parte order, meaning an order without notifying the other side, must submit an affidavit of good and sufficient reasons why a procedure other than by notice of motion is necessary, and stating whether a previous application for relief has been made. And none of that was submitted here. So accordingly, the court issued an order declining to enter the order to show cause, directing service on the defendants, not only of the motion, but also of the complaint, so that the defendants could be heard. Jordan and the judiciary filed a response. They say Bragg's not going to succeed on the merit. They say Jordan and the committee are immune from lawsuit, speech and debate clause. They also say the subpoena is totally valid. We have perfect legislative purpose. 1, protect former presidents and presidential candidates from politically motivated prosecutions by district attorneys all throughout the country. And they say that this could have an impact about how cases could be removed from state level to federal court, which we talked about. They also have the right to investigate funds. Now, Pomerantz also filed a response, which we have not read. He describes himself as a nominal defendant. It says, the judge writes, it appears that Pomerantz is content to largely allow Alvin Bragg to speak to him. The judge continues, saying the day before the scheduled hearing, Alvin Bragg filed an 11th hour reply brief, not authorized by this court's order, given the time frame in which this motion was filed. Says Alvin largely rehashes the same arguments made in the first brief and finally addresses the speech and debate clause. says Alvin's brief was accompanied by a supplemental declaration attaching 16 largely irrelevant exhibits. The judge, what are you attaching this crap for? It consists of a hodgepodge of social media postings, news articles, television interviews, pleadings from unfounded lawsuits, and a transcript from the arraignment in the Trump prosecution. The judge is like, what are you giving me all this garbage for? The court is also in receipt of several unsolicited amicus briefs. People are filing motions saying, we're friends of the court, and we want this to go this way and this to go that way. And the judge says, I'm not inclined to hear any of that. Says an assemblage of former members of Congress, former prosecutors, former government attorneys, and former academics filed an amicus brief, all with the consent of Alvin Bragg. So Alvin Bragg's on his phone. He's like, oh man, I'm in deep doo-doo over here. Who can I call? And just like the Democrats like to do, they like to create lists of people who are idiots, and then they all sign a document saying a thing. And they like, look at my list. We saw this with the Hunter Biden saga with those 51 plus so-called intelligence experts who are not experts and not intelligent. They all signed this thing saying that the Hunter Biden laptop was Russian disinformation. Obviously, that was true. So the same type of tactic is here. They think that their lists give them power or something because they argue by appeal to authority. We've got science. We've got justice. We've got all of these things. So all of these idiots, former government lawyers, former prosecutors, they've got nothing better to do. They just forward emails to each. Can you sign this thing? Can you sign this thing? Can you sign this thing? Gosh, idiots. So they all sent in a bunch of letters, and this judge is saying, why did you send me unsolicited amicus brief, morons? Says the amici, the friends of the court, argue that the committee lacked authority to issue the subpoena. Judge says it's not their opinion, and they echo Bragg's refrain that the subpoena is going to interfere with an ongoing criminal prosecution brought by a state prosecutor. A separate group of former state and federal idiot prosecutors filed amicus briefs, again with the consent of Bragg. He's like, yeah, file it again. Send the list. Did John sign it? No. Did Jim? Get him to sign it. These amici assert, and I honestly, these people are doing this, right? They're having Zoom meetings. They are like, I'm not joking. Like, yes, we're joking about it here, but this is also real. Remember that after the 2020 election, they revealed to us how they did it, how we did the thing. And they said that they organized everything in the Time magazine piece, and they had they were holding weekly briefings, and they were organizing all the teams together, rapid response groups and all this stuff. They've got whole teams built out around these prosecutions and around these cases. So here they are doing that. Another batch of federal prosecutors filed another brief. And they say that these amici, this seriously challenges the prosecutorial process. All right. So the judge says, look, Bragg and his two sets of amici attack what they describe as federal interference in this prosecution. There is no question, says the judge, that New York is a sovereign state in our federal system, that it has authority to enforce its criminal laws through its local prosecutors, and says the court is mindful of potential federalism concerns, the separation between the feds and the states. And now Alvin Bragg is suddenly a sovereign states' rights person, miraculously. It's amazing what happened. However, the court rejects the premise that the committee's investigation will interfere with the prosecution. The subpoena of Pomerantz, who is a private citizen and a public commentator at the time that Bragg indicted Trump, will not prevent or impede the criminal prosecution that's currently pending in New York at all. So they go through some analysis. The judge says a threshold issue. Does Bragg have standing? The judge says, yeah, Bragg has standing. He can file a lawsuit. But Bragg is not entitled to a temporary restraining order. In the Second Circuit, we have certain rules that govern the issuance of restraining orders. And in order to do so, you've got to establish a likelihood of success on the merits. But here, congressional committees do have constitutional authority to conduct investigations. The House has the power to legislate. The power is not limitless, but they may conduct inquiries into certain things, of course. The court finds there are several valid purposes here. Federal funds, forfeiture funds, congressional authority, all of the things we've already touched upon, they are detailing for us in a little bit more, with more detail. Here, the subpoena also does not implicate sovereign interest of New York. It's not undermining New York. This guy's a private citizen, not even involved with the office anymore. So you guys are free to continue your historic prosecution of Donald Trump. Jim Jordan is free to ask Pomerantz about the prosecution. The subpoena is only asking for Pomerantz's testimony. They don't want any documents. And as we scroll down, it says, finally, Pomerantz is not involved in the prosecution in any way. So we're going to see that, there may be something, a difference, something to distinguish if Bragg is actually subpoenaed, right? That would be a big difference. All of these arguments would then be moot at that point. Jim Jordan has already sent a letter to Alvin Bragg, but no subpoenas have gone out to anybody other than Pomerantz. So in this case, yeah, Pomerantz is not involved. So the pending prosecution will move forward regardless. He wasn't even employed at the office when Trump got indicted. So it wouldn't impact the prosecution. But what happens if this goes over to Alvin Bragg? And Alvin Bragg actually gets the prosecution. So let's see where this wraps up as we scroll down to a little bit more concluding language. We find the judge carries us out and says, for the foregoing reasons, the motion for a temporary restraining order enjoining the subpoena to depose Mr. Pomerantz and stopping Pomerantz from appearing is denied. Judge says, in our federalist system, elected state and federal actors sometimes engage in political dogfights. Bragg complains of political interference in his case, but Bragg does not operate outside of the political arena. Judge says Bragg is presumptively acting in good faith. That said, he is an elected prosecutor in New York, and he's got constituents, some of whom wish to see Bragg wield the force of law against Trump and the current Republican presidential nomination candidate. Jim Jordan, in turn, has initiated a political response to what he and some of his constituents view as a manifest abuse of power and nakedly political prosecution funded in part with federal money that has the potential to interfere with the exercise of presidential duties and also with an upcoming federal election. The court does not endorse either side's agenda, but the sole question before the court today is whether Alvin Bragg has the legal basis to quash a congressional subpoena that came with a valid legislative purpose, which is such a low bar, the judge says he does not. The parties are encouraged to speak to one another to reach a mutually agreeable compromise regarding how the deposition of Mr. Pomerantz will proceed, but it will proceed. This court will retain jurisdiction over this dispute and any ancillary claims arising out of the inquiry by the committee related to the use of the federal funds in a manner that may influence the 2024 election. Judge Visikill says, in other words, Braggs may not file successive proceedings under a different index number if and when the committee in fact issues another subpoena that he finds objectionable, or if there are issues with respect to the Pomerantz depot. Judge says the parties are hereby ordered to file a joint status report within 30 days of this order. So ordered. New York, April 19th, Judge Mary K. Visikill. Beautiful. So this closing is the judge saying, I'm going to hang on to this little predicament here, Alvin. If you get another subpoena and you file a motion to quash that subpoena, whatever's going on with any of these subpoenas from Congress on this issue, they're in my court now. I'll be taking control of them. Thanks. Because it's Congress. And we have a separation of powers problem. If the judges can just tell Congress what to do, we learned this back during January 6th, and they wielded that power like maniacs. And we're going to see what happens to the fabric of this country now that they've crossed that bridge. But the Republicans can do the same thing, and they can wield the power of Congress just like Liz Cheney did and go beat up whoever they want about it peacefully and politically in court. But this is a great ruling from the judge, and the judge was very smart on this. I mean, she was even calling him out, saying that he was filing this as he filed this inappropriately. He should have responded in a different way. He filed a lawsuit instead of a motion to quash a subpoena because he was trying to be sneaky about this, and says, if you're trying to be sneaky again, Alvy, it's coming to my court. I know what you're doing. Don't try it again. Mark Pomerantz is sitting for a subpoena. Any problems with that, you let me know. So we'll see where that goes. It's going to be a lot of fun to see what happens. Now, that's provided that this does not come back down on appeal, because the Alvin Bragg has already submitted this on appeal. Remember that the order in the subpoena was that Mark Pomerantz show up on the 20th. That is today. So as soon as that order came down, Alvin Bragg flipped right around and filed an appeal. And this is what it looks like. The judge issued an order and says, all right, now this is pretty normal, right? Alvin Bragg and Mark Pomerantz, they both appeal from a district court order, the one that we just read, denying the injunction. The subpoena return date is today, April 20th, 2023. So a court of appeals stopped this before he had to show up. They say appellants have filed an emergency motion seeking an interim administrative stay and a stay pending appeal of the return date of the subpoena. Of course, Jim Jordan opposes that. The Court of Appeals said it is hereby ordered that an administrative stay of the return date of the subpoena is granted so that a 3-judge panel may consider the motion seeking a stay pending the appeal of the order. The order reflects no judgment regarding the merits of the parties' positions. All right. So this is basically just a temporary hold. And this happens regularly. You know, we see this all the time. The appeal tolls the imposition of the lower court's ruling generally, and then it is carried over and dealt with later. Here, the court is ordering. The appellee's paper in response to the motion are due on April 21st, tomorrow, at 3 p.m. The reply is due April 22nd at 3 p.m. The clerk is directed to calendar the motion for the first available panel. All right, so this is moving very fast. We have the 21st is a Friday, the 22nd is a Saturday. Then we'll probably be back on Monday for first available panel. I don't know when the full court panel will be, but next week maybe. Is there a panel? We don't know. But if there is, then the subpoena might be deemed to be valid. We might have Mark Pomerantz going over to the Judiciary Committee maybe by the end of next week or soon thereafter, provided the Court of Appeals agrees with the lower level district court. And I think that they will. The higher court may not agree with some of the language in there. No one is above the law and some of that characterization, but it is Congress, and Congress, as we've seen here on this channel, has had a lot of precedent in getting what they want, even in spite of what we think are egregious requests and egregious claims. They got it anyways. So of course, a lot of activity on this. Alvin Bragg is going to continue to fight for his survival now that he has crossed the Rubicon. He's going to have a lot of support as he does it. You saw that Pomerantz has all of his federal prosecutor buddies all sending in letters as amici of the court. The judge, I don't even want to hear it. Take your lists, go to your cocktail parties, and leave the rest of us alone. Of course, we'll continue to cover it. Thank you for liking this video, wherever it is you're watching. Thank you for subscribing. We're going to continue to cover all of the Trump prosecutions and more. And we'll see you on the next one.